Okay, good morning or good afternoon, should I say, everybody, and welcome to our webinar today on GDPR, focusing on the implications for HR. So thank you for bearing with us there. We had a couple of minutes technical hitch, but you will all hopefully have noticed that there was no private or personal data on display on my screen. So there we go, first tip of the day. If you ever think you are about to anticipate people coming in or seeing what you're about to do, just make sure that everything is completely away. So spot the deliberate mistake. So as I said, welcome everybody to our webinar today. This is, of course, further to the webinar that was held in June on GDPR. And today we will be focusing on the implications for HR and paying particular attention to two of the more data-specific areas of HR that you either already are aware of or will be facing in the future. And those are data retention and dealing with subject access requests. So before we do get underway, we just want to introduce ourselves. So my name is Karen, and I am a newly appointed HR Knowledge Manager for HR Solutions. Today I also have with me my colleague Sue Watson, who will introduce herself.
Hello everybody, good to be with you this afternoon. So I'm here just to keep an eye on things and make sure if any of you have any questions or technical problems, send us a message through the chat and I will see if I can help you with them. If you have a number of questions about the GDPR topic itself, then we'll probably won't have time to address those during this webinar, but you can send them through to us and we will respond to you separately direct. If you would like a copy of the presentation, then we can send you that through as well. Just send us a message requesting it. Okay, thank you. I'll hand you back to my colleague.
Okay, thank you, Sue. So for those of you that have been on our previous webinars, that does mean that we're saying goodbye, unfortunately, to our good colleague Alison. She is leaving us, and we're very sorry to see her go. She's leaving very big shoes for me to fill, but she does assure me they are only a 6, so hopefully it won't be too much of an issue for me. Okay, so that's me there, and that's Sue. And so here are our aims for the webinar today. So we're going to look at doing a quick recap on the key aspects of GDPR to provide you with a practical guidance on how to become GDPR compliant, to understand the components of a data protection impact assessment, to understand what you need to be able to keep personal data, so what you need so that you can keep personal data and why you will need to keep records, to understand when and how to report a serious data breach, to know how to effectively deal with subject access requests, and to understand document retention requirements. Okay. So to start with, just doing a recap on GDPR, many of you might be familiar with some of the key principles of it already, but for those that aren't, I just want to get everybody up to speed really. So to put it simply, let's look at the who, the what, the when, the where, and the why. So the questions we might ask when we're in a panic, as many people I speak to about GDPR seem to be, apart from the ones who are imitating an ostrich, that is. So let's look at who. So it is a regulation that's been written and enforced by the EU government. There are limited areas in it that are left up to the discretion of the member states to decide how they wish to implement it, which leads me on to what. So what is it? It is a regulation and a directive, and that for us is the Data Protection Bill. And the aim of these are to essentially protect the human right to privacy and to protect personal data. So when is it going to apply? So if you don't already know, it's quickly knocking on our doors. On the 25th of May 2018, we will be obliged to be compliant with this, okay? So it is something that is in effect at the moment already, but it's from the 25th of May next year that we are going to have to be compliant. And where? So as you may guess from who's written it, it's going to be applicable to all EU member states. Put simply, it will also apply to any organisation outside of the EU who processes data in the EU or processes data about a natural living person who resides in the EU. Okay. And why? So we already have the Data Protection Act. Why do we need this? Well, that was written in 1998, and if you remember, the internet was only really getting to its feet in 1995. So a significant reason that this has been put through is the need to keep up with the quickly developing digital age that we're in, which, you know, we do come to rely quite heavily really on data in the day-to-day runnings of our lives. If you think about how much data we pump into the internet at the moment, gigantic organizations like Google, Facebook and Apple, all dependent on our data. And the question of Brexit. So we might be out of the EU, but we will not be out of the reach of the regulation. Okay, the Data Protection Bill is still facing some scrutiny, but it has been written by our Parliament specifically to implement the regulation so that the UK remains compliant and will be able to continue to trade across our borders after Brexit. So you might hear the term supervisory authority now and again when looking at GDPR, or SA as it's abbreviated to. You're quite likely to have heard of ours already, or at least you probably should have done, as you will all most likely be registered with them already. So our supervisory authority is the Information Commissioner's Office, or the ICO, as they're more commonly referred to. Our continued compliance with the regulation post-Brexit has been further confirmed by the ICO and will carry with it the same levels of enforcement. And so how will it be regulated? Well, there are a few ways in which the principles will be implemented and upheld. We do have some standards, marks and data seals that you will be able to obtain in order to try and demonstrate that you have achieved compliance. So for example, we have the ISO 27001, which is a BSI accredited standard specification for information security management systems. These seals and things like that, they aren't presently with us, apart from the ISO, of course, but ultimately they will be backed by the EU Data Protection Board, any decent ones that is. So if you do want to try and obtain one of these marks or seals to demonstrate to your staff or to other businesses that you deal with that you are compliant with this regulation, do look to see whether or not it has been accredited by the EU Data Protection Board. And then ultimately, as with any legal requirement really, the ultimate way in which it's going to be regulated, of course, is through any civil rulings or criminal court systems that come through, as is often the case with employment law. You know, we get a lot of our learning from case law and tribunals, and so as and when those things come through, we will start to understand a little bit more as to how the law is going to be interpreted and what we need to do accordingly to comply. So if we do fall foul, ultimately organisations can be fined up to 4% of their annual global turnover for breaching GDPR, or 20 million euros, whichever is the highest, okay? And that is the maximum fine that could be imposed for the most serious types of infringements. Examples of these would include not having sufficient customer consent to process data, violating the core privacy by design concepts that's written throughout the regulation, and by violating the rights of data subjects, particularly by sending any personal data outside of the EU. So there is going to be a tiered approach to the fines. For example, a company can be fined 2% for not having their records in order, and that's written under Article 28. For not notifying the supervisory authority or data subject about a breach, and not conducting a proper data protection impact assessment when it's required. Okay. So data subjects who think their rights have been compromised will also be entitled to bring a case against a data processor or controller, and they may be awarded damages if this case is successful. Potentially, there's no ceiling for that at the moment, and this could have quite an existential impact on some organisations, as you can imagine. So what are the principles of GDPR that we're looking at? Well, there are 6, and the overarching principle is accountability. So that's what these 6 are trying to achieve and instill in us. We're looking here at lawfulness, fairness and transparency. So that's in relation to the data subject. Purpose limitation. So has the personal data that you've got been collected for a specified, explicit and legitimate reason? Data minimization. So are you only collecting what is necessary and relevant? Accuracy. You must take every step you can to ensure that data is up to date with regards to the purpose that you've collected it for, of course. Storage limitation. So this actually means that it needs to be kept in a way that identifies a person for no longer than is required. Okay. And lastly, we have integrity and confidentiality. So this is about ensuring that security is used where appropriate, or using appropriate measures, I should say, to ensure that it's kept absolutely private and secure. Now, if you can get to grips with these 6 principles, taking them seriously and trying to do whatever you can to achieve them, then you'll be winning half the battle, okay? And as I said before, the key is to remember that this is all about making you accountable for what personal data you hold, and that you're using it for really specific, clear purposes and only for as long as you need to. So if you can really get to grips with that, as I say, you're winning half the battle. Now, what I want to do really is look at some practical steps that you can take to actually help get your organisation and specifically, of course, your HR sorted out and ready for GDPR so that you can be compliant. Now, I have put together a set of 5 steps that I'm looking to talk to people about. Hopefully, by achieving those 5 steps, you will be compliant with GDPR. Now, the ICO have put together a 12-step program as well, and this is free to view online, and it's something that I wanted to direct you to just to give you a bit more peace of mind. But there is actually nothing at the moment that specifically says if you do A, B, and C, then you will be compliant, you know. And in fact, as with those data seals that we looked at before, they're still going to be essentially codes of conduct, you know, and recommended practice. So even if you were to achieve one of those data seals, you're not necessarily guaranteed of being compliant. It's only really if we're ever challenged and the finer points are discussed that we will ever know whether we've done the right thing or not. But, you know, this means that it falls to people like us, or if you are stuck for a bit of bedtime reading, we need to sit down, look at the regulation and what it actually says, and put together a checklist to meet compliance. So these are my 5 steps, okay? First, let's look at auditing everything that you've got. So get rid of anything that you don't need now. Organise and minimise what you have so that you're avoiding duplications, okay? The less you have and the more understanding you have of where it is and how to access it, the better control you're going to have over your data, and the less likely you are going to be that you ever have any personal data breaches. You then need to set about ensuring that you have identified the roles that you have. So through the regulation, we regularly talk about a controller, a processor, a data protection officer, the data subjects and third parties. Okay. If you can identify who these people are in your organisation, you'll then be able to look at assigning responsibilities, okay? So essentially the controller is the person or organisation responsible for deciding how data is processed and what it's processed for. So this is quite likely to be the person at the top of your organisation, which might be you, or might be somebody that you support. processor, in short, is essentially anybody that is moving data around and using it in their day-to-day operations. A data protection officer, now that's something that you might not necessarily need if you are going to be processing a high volume of special category data, and we know that at the moment as sensitive data, you will need a data protection officer. Or if the day-to-day runnings of your business rely on a high volume of personal data at its core, then you will need a data protection officer. Your data subjects may well be self-explanatory. So in this context, that's really going to be your employees, but it may also be candidates that you are recruiting. It may even be contractors that you work with, and agency workers, of course, that you might get through recruitment agents. And third parties then is anybody else, so anyone outside of your organisation that you might have dealings with, such as, for example, employee databases. If you subscribe to any of those to record your employee data, that's a good example of a third party. Again, recruitment agents and so on. Your second step is the data protection impact assessment. So I say essentially, you will need to have privacy by design written through all the processes that you have to ensure that any personal data is kept securely. That is mandatory now. The data protection impact assessment is going to be obligatory if you are processing a high volume of special category data. Okay, so when you're looking at HR, this is something that is really going to be imperative. And we're going to look at that in a degree of detail later. The fourth step is records. So personal, I'm going off the screen a bit there, but personal, special, or criminal record data that is processed, you will need to be keeping records of what that is, why you're keeping it. And the last step is going to be breach. So are you going to be able to report a serious breach within the designated timescales, which is now 72 hours? So a data protection impact assessment. You've got to have 7 elements in a data protection impact assessment to ensure that you have met the obligations within it. And I think that really the components of this are just a good standard and a good measure and way in which you can ensure that you've implemented privacy by design through your processes. So in all your HR processes, let's firstly identify what the purpose is, on what legal basis you are obtaining the data, ensuring that your data is proportionate to the means, that you would be able to describe a step-by-step account of what these processes are, how you obtain the data, how you store it, and how you remove it. And this must include data security by design. Risks. So this is going to be a key part, really. You need to risk assess your processes. Be aware of how and where you could be at risk of a data breach. And then you need to look to put in place measures to mitigate that risk. And lastly, the 7th step is views. So this is only a recommended step, but where appropriate, you should look to get the views of your data subjects regarding the processes that you have. So I would suggest that as it's written into the regulation, you should try and look to comply with it wherever possible, unless you have a justifiable reason not to, of course. It may well be that to solicit the views of your employees and staff at a time where it's not appropriate could just lead to more problems than not. So I do really think that you should consider how and when it might be appropriate for you to solicit these views. So, for example, it might be that you have a legal reason as to why you are obtaining some personal information. And in those situations, there's not really going to be any room for debate as to whether or not that's something that you should be collecting. For example, obtaining the rights to work of people that you've newly recruited. However, it might still be possible that you can discuss how this is best done. And so it's really up to you to decide how and where it might be appropriate to look at getting the views of your employees involved in how you process your data. So this was the second step of a data protection impact assessment, and it's something that I wanted to go into a bit more detail on with you all. You need to have one of these 6 reasons to be able to obtain and process data lawfully under the GDPR. Okay, so the first area that we're looking at is consent. All right, so consent is something that we rely on quite a lot at the moment, and is something that we quite often use, for example, at the bottom of contracts, at the bottom of offer letters. Whenever you hand a form over to a member of staff, you're quite often getting their signature at the bottom. We're very comfortable with it, we're familiar with it, and that's great. But it may be that when the GDPR rolls around, we try and rely a little bit more on one of the second 2, so contractual requirements and legal obligations. I'm going to talk about these a little bit more in detail, but just to cover off the others, we also got vital interests. Now that's very unlikely to ever be a legal basis upon which you will be obtaining data for your staff. Public interest and legitimate interest are the other 2. So public interest, if you're a public body, it's a matter of public record to obtain employee data, fine. Legitimate interest, if you've got a justifiable business reason for obtaining it, then potentially, yes, you could use that as your legal basis for obtaining data, but potentially has a lot of scope to be woolly and to be debated as to whether or not it really is a legitimate interest. So I do think we should really try where possible to look at relying on a contractual legal basis or a legal obligation. And actually, if we think about HR, a lot of the personal data you get is probably going to be under a legal obligation. So if we start at the beginning of an employee's life cycle, I mentioned before, you will need to obtain right to work documentation. There's no ifs or buts about that. You've got to be able to evidence that your staff have got the right to work in the UK. So straight away, you will have passport details, visas, birth certificates, national insurance numbers. They're all things that you will be obtaining under a legal obligation. If you need your staff to have a DBS certificate, then in order to obtain that certificate, you might even get to familiarise yourself with who provides their gas and electricity when they're providing bills to prove who they are and what their addresses are. Let alone, of course, the convictions that they might need to disclose to you if there is anything on a certificate. Certain jobs as well might require you to obtain other documentation, such as driving licenses. You might need NMC PIN numbers if you employ nurses, insurance documents, for example, of doctors and home workers, and so on. The working time regulations. So this requires you to be able to demonstrate that you are not in breach, and to do that you might have processes in place such as fob systems and entry cards. You might be able to justify the use of these under the working time regulations. Timesheets, hours worked, pay records, all to evidence that the national minimum wage has been met, as well as the requirement to keep tax records, for example, for the HMRC. Payroll and maybe HR will receive your staff's SSP notes in order to process the statutory payments, which is highly likely to contain details of their illness, and quite likely, of course, to contain their name and even marital status at the top as well. Auto-enrolment. So that requires you to offer qualifying staff a pension. So you'll have details of their schemes. And then there's many statutory rights that would need to be cautious of, including here as well, including issuing a statement of main terms or a contract within 2 months of employment. In order to be able to do that alone, you're going to need a certain amount of personal data. To process family-friendly rights, particularly pertaining to pregnancy, for example, you're going to need a lot of information. Rights to be treated equally, and without discrimination. This might not necessarily mean that you are legally obliged to find out about protected characteristics of your staff, but it would mean that as and when it becomes important, you may need to have an awareness. I.e., if you have an employee who will need regular adjustments made to their working pattern or duties to observe religious practices or to accommodate medical conditions, then you would need to understand what their protected characteristics are. In a redundancy situation, you will need to be aware of any characteristics, particularly pregnancy again and trade union activity. So speaking broadly, that you are giving first refusal of suitable vacancies to women on maternity leave, for example, and including unions in consultation where necessary. This would also perhaps give you cause to retain disciplinary capability and other medical records. In the interest of consistent application of these processes, you'll need to record details of circumstances, such as your investigation and disciplinary packs, as well as the outcome letters, so that you are treating everybody the same. Under contractual requirements, you may make an offer of employment dependent on satisfactory references, in which case you may require the personal data of others. Under contractual requirements, again, we might ask staff, as I said before, to sign contracts and offer letters and so on, largely to agree to the finer points of the terms that you've put in place. You might also need restrictive covenants to be signed, and this would be a contractual requirement. You may offer benefits as well, such as childcare vouchers, health and life insurance. They could be justified under a contractual requirement. Some of you may have vehicles and fleets that go out, and you may have trackers on those vehicles for insurance purposes, but also they will mean that you are identifying the location of your staff and their habits as to where they are. This would all be personal data that you're recording, and again, that could be justified under a contractual requirement. So actually, you might agree that we've covered quite a lot of personal and special category data just under those two. Consent, of course, is still going to be a valid reason that you might need to obtain things. Certainly, there may be many aspects of your HR process that are reliant upon consent of your staff to hold their personal data, such as agreement to use their photographs, for example, in marketing or on your website, to contact their GP for medical records or an occupational health assessment. You might, you will require the consent of a candidate to receive their CV. So there's going to be a really high volume of personal data on somebody's CV. So you may well need to look at adjusting a privacy statement that you have that expressly and clearly states that by submitting their CV, they're consenting to your organisation using this for the restricted purposes of recruitment. And I think consent there is perhaps something that many of you will want to know a little bit more about, particularly whether or not you need to obtain the consent of the staff that you have, again, for data that you already have. Not necessarily, no, but it may well be strongly advised. So the information you're likely to already have on employee, as we've discussed, is data that is probably required under one of those other two legal bases as discussed. You will only need to get consent again from staff that you have if the consent you have doesn't meet the following criteria, and I'm afraid there are quite a few. There are 2 pages of this. Okay, so remember, this will be going on our website again, so you can flick back and have a look, but to look at some of the key ones, to obtain consent properly, you will need to have advised your staff and candidates as well, of course, of the contact details of the data controller, the contact details of a protection officer, if you have one, the specific, legitimate and fair purpose for collecting the data, and the legal basis upon which you are collecting it. So of course, in this case, it may well be consent, but if you do have others that you could rely on, you might want to include those as well. Who the recipient of the personal data will be, and any third party that you might be sharing it with, and how and where they can obtain a copy of who to speak to about that. You should also include how long the data will be stored for. Advise them of their rights to request access to this data, to rectify it, to restrict it, or even erase it, to object to the processing, and to advise them of their rights to have data portability. So that's not just, can I pick it up and move it around? That's whether or not the data well, that's the fact that the data should be in a common format. And essentially what that means is something that everybody will be able to access on a day-to-day basis. You may have experience of receiving attachments, for example, from people and not being able to open it because it's in some higgledy-piggledy file that nobody's ever heard of before. You might email back and say, look, can you try and resend that again for me, please, in the PDF? That's a good example of what this means, okay? Needs to be in a common format that most people would be able to view. You would also need to advise an employee about their right to make a complaint to the ICO if for any reason they are dissatisfied with the ways in which you are processing their data. And there are some others there too. Now, an interesting question at the moment on the issue of consent is whether or not you would need to get the consent of the author of references to keep their data about the referee. And if you ask your employee to provide details of their next of kin and so on, do you need the consent of the next of kin member to hold their data? Well, it's a little ambiguous, but I've looked into this. Article 2 in the GDPR, if you wish to check, states that the regulation does not apply to the processing of personal data by a natural person in the course of a purely personal or household activity. So is asking your partner or family member to be your next of kin a household activity? I think probably yes, it's domestic. But once that data on that reference or on that next of kin form is passed into your organisation, do you then have obligations to that party? Well, I would suggest that you do, because you don't necessarily have to be the one that collects the data directly in order to be the processor. So I would strongly recommend that you consider revising your processes so that you demonstrate at least an attempt to inform and obtain consent from the next of kin or referee or whoever it might be, that you will be in possession of that data, and that they agree that you may be in possession of that data. So this could mean amending new starter forms to include the signature of the next of kin, for example, or amending reference request forms to be more explicit with a privacy notice on it, and so on. So, retention and destruction. Following on from consent, not only can personnel withdraw consent they might have given, but data subjects will also have the right to erasure under certain conditions as well. It's going to become important that you familiarise yourself with how you actually destroy data so it is suitably erased. Most HR departments are probably going to have secure bins, for example, for shredding sensitive documents, which is serviced by professionals. So you will also need to have state-of-the-art IT equipment really where possible. If you're not already, you should try and get friendly with your IT department, and they should be able to advise you on software for completely removing files when they're no longer required, so that it would be exceptionally difficult for them to ever be restored, if not irrevocably restored. Remember that in the event that this right to erasure is invoked, you would be required to remove traces of that individual from any backup servers and files that you hold as well. Okay, so this is quite extensive and far-reaching. Now, at present, you are able to remove files that you no longer require as and when you have the time or inclination to do so. But as of the 25th of May, you will be required to inform a data subject whenever you update or remove their personal data. So if you recall my 5 steps we had towards the beginning, the first of which being audit, I would suggest that you strip out what you don't need to know now. Once you've got rid of what you don't need, get it organised, and then you should increase your level of control. So just some examples here of how long you might need to keep things. I've got a bit of information up here on the screen for you, and it is based on some historical acts and regulations, but it's all we have to work with, really, I'm afraid. So as an example, we have employee, personnel and training files at the top here. Now, it is advised that you keep those for 6 years after employment ceases, but you might have all kinds of things within those that you actually think, well, do I really need the entire contents of that? Certain things you will, of course, like any accident records that you might keep about the respective employee on their file, maternity leave documents, disciplinary grievance documents, you know, they all have slightly different rules around them. Certainly looking here at discipline and grievance, you might be able to strip those out soon after a warning has expired, for example. So it might be that you want to start thinking about how you're organising your personnel files so that you might be able to automate stripping out some of this information as and when it's no longer required. So you might want to, again, speak to your IT, or if you're savvy yourself, about data stamping your documents. Now, if we consider back the principles, 3 of those really emphasize the fact that we need to limit and restrict and reduce what we have. So when thinking about destroying and removing what we don't need, I'd put to you that perhaps once your purpose for obtaining that data has been met, it may no longer be necessary for you to retain all of the personal data that you collected. And so this is going to be a good opportunity to prompt you to look at minimizing your data. For example, once you've finished recruiting, or as we said before, when an employee leaves. So start thinking about trigger points that you might have within your processes that could be a good opportunity for you to start doing a bit of clearing out. Now, alternatively, it may be that you still need some data, but that it's no longer necessary to store the data in a manner that specifically identifies an individual. So, for example, reporting, if you do monthly or annual reports on sickness and absence, or employee turnover, retention, and so on, number of disciplinary cases, etc., then within your information system that you use to generate that report, or an Excel spreadsheet, you might document names currently and start dates and other identifiers. It may well be that actually after a period of time you decide that either A, you could strip these identifiers out totally without impacting on the accuracy of the reports that you have, or B, that once you've generated the figures that you could class as historic, but perhaps for whatever reason you still need to keep them to identify trends and things like that, then you can extract those figures and remove all the other identifiers. Okay, and this type of minimization is called that. So good luck anybody who's trying to wrap their tongue around that at the moment. I've struggled to manage it and then don't intend to attempt it now. Moving on, looking at record keeping and why it is necessary. So stage 4 of the process that I set out for you before, you will need to keep adequate records if any of these apply. Okay, so if it's likely that the rights of the data subject could be at risk, if processing of personal data is regular or frequent, which I think we could all probably agree in HR, yes it is, if special category data is processed, or if information relating to criminal convictions is processed. So I think all of those really pretty much are intrinsic with HR. And what you will need to record. So when you're setting out for the purpose of GDPR, what processes we have and what personal data that uses, you're going to need to keep details of your controller, who they are and how they can be got in touch with, the purpose of the processing, categories of data subjects. So as I mentioned before, not just employees, but perhaps also people applying for jobs with you, so candidates, agency workers, self-employed contractors that you might have, and so on. and the categories of personal data. Okay, so that's things like addresses, names, medical records, and so on. Categories of recipients of the personal data. So in a HR context, that's quite likely to just be line managers, for example, but it could also, of course, be GPs, occupational health therapists, EAP programs, potentially pension scheme providers, and so on. And then the security measures that you have in place to protect that data. And these need to fall under one of these two areas here, okay? So they do either need to be technical, well, sorry, they should be both. You should have both technical security measures. So we're really looking at things like IT there, quite well, most commonly, and organizational measures, okay? So how you're actually arranging your HR team, for example, might be quite key. You know, where are people sitting who are doing key jobs? Are they going to be overlooked by people walking past? But also just where are we keeping files and folders? And of course, I know that you will need to have contingency planning. So where are you keeping that second file or folder, for example, as well? You will need to be documenting what safeguards you've used in respect of any transfer to a third party. Okay, so as I said before, if you perhaps do use an employee database provider, start speaking to them about what safeguards they have and how they're being compliant with GDPR, and discussing how you are going to transfer data to them, and the duration that the personal data will be kept. Now, if you don't know exactly how long the personal data is going to be kept, because it's dependent on, you know, X, Y, and Z, then that's fine, but you will just need to make sure that you're documenting the criteria or the rationale under which the duration will be defined. Your processors will also need to record their details, so you might as well just keep all of this together. And if they do work on behalf of any other controllers, you will need to ensure that they are documenting who else they are representing. Now, moving on to the topic of subject access requests. So this might be the face you feel that you pull if you find out that someone's putting one in. I think they most commonly tend to come in when you have a disgruntled employee, or perhaps when someone's leaving. So it's not always the most positive of circumstances that you get a subject access request. And all the more reason really why you should be prepared for them. Now, when GDPR comes into effect, we will no longer be able to ask for a fee to process a subject access request. And rather than the 40 days that we had before, this is reducing to 1 month. So your data subjects can ask to have any inaccurate data corrected. They can ask for information to be erased, again, provided that you don't have one of the other legal bases to continue to hold that data on. They can request a copy of the information, and it must be in that portable format, as we spoke about. They can ask to be told whether any personal data is being processed, and a description of the personal data, the reasons it's being processed, and whether it will be given to anybody else. Now, this is something that they should really have been advised of already, particularly if you are relying on the legal basis of consent. So it should be something that you already have documented. And they should be given details of the source of the data if it wasn't from them that you obtained it. So in HR, it's unlikely that you're going to have got data of your employees from anywhere other than them. But I think particularly with recruitment, that may well be a key area where you're going to be obtaining data from another source. And so you would need to have records of this. Now, if you were to get a particularly vexatious situation and someone's putting multiple requests and extensive requests in and making them unreasonably, then it is going to be possible for you to look at putting a fee in place in that particular instance. But otherwise, it is no fees anymore, and you must comply within 1 month. So just look to see whether or not you are going to be equipped to manage with these requests in the shorter timescale. If you have properly audited your information in advance, then it should be much quicker and easier for you to lift out anything that relates to a particular individual. I'd recommend that you have a procedure in place for handling these sorts of requests. Again, just to speed up the process as and when one should come in. And equally be able to rectify and update any inaccurate or incomplete data, and to remove it as well. Hence why it's a good idea to get talking to everybody who might have a copy, to minimize any copies that you don't really need, and to understand how you can completely remove data that you might be holding. Now, I just want to talk quickly about the concept of data flow, just to help you think about how you're going to identify any potential areas where there could be a breach. So data flow is not a new concept, but what does it have to do with having an assessment and designing security measures and privacy measures? Well, I've used this image because I wanted to try and use the idea of petrol and how we obtain that. If you think about it as a metaphor, where it's sourced, we get petrol, we just take it for granted that we can just go and get it down the road. But if you think about it, that has been sourced, it's been extracted up and processed through a rig, transported through a tanker and driven or shipped to a petrol station. It's offloaded into a container, and a series of purposefully designed pipes and networks are distributing it up to pumps, and then a purpose-built handle, allows petrol to be deliberately released as and when it is required. And each step of that process has been designed so that not a drop of that, theoretically can escape, because it is so valuable. And if we do lose it or it leaks out, it could be dangerous, and costly. I don't know if that's a bit crude, you might think so, but if you try and consider your data in a similar sort of way, and just try and think about where you can plug any gaps or weak areas where it could be able to leak out, then you should be thinking along the right lines of how you need to consider your data and the importance that you should be placing upon it. So I mentioned before that you would need to have technical and organisational measures in order to minimise the risks that you have, and to minimise the risks that is breached. So here I've gone through a series of processes that you might have within your organisation, and I'll just pick out a couple. So in recruitment, for example, it's quite likely that you're going to be having calls and emails coming in from unknown people. It's going to be important to think about training your staff to be stringent with calls, particularly from people that they don't know. It's all too easy for people to give out information, when they think that the person they're speaking to has got legitimate interest, and tell them, Joe Bloggs isn't in today, they're going to be away from their computer on annual leave until the end of the week. You could have just told a person, who's a professional hacker, that there's a computer sat there free, that they can attempt to try and access for a specific period of time. So start getting your staff savvy on how to pick up things like that. Social engineering, if you want to have a little look on the internet a bit more about how you can train your staff against that. Also consider how you're going to automate the removal of unsuccessful candidate applications. And why not consider monitoring your response rates as well? If you've put out an advert for a job and you receive, 50 CVs in the first week, and you've got really strong applicants within there, it might not be that you need to continue having your campaign out for another 3 or 4 weeks, collecting hundreds more. So it's all just about rethinking how we approach our processes. With new starters, at the moment, quite often, we have people filling out new starter forms when they begin on a piece of paper. But if you think about that, you have to get the person in, sit them down somewhere, other people walking past, they then have to transport that bit of paper across a room or to a different department. It sits on someone's desk, it then has got to get inputted by another person who's looking at it. They could make mistakes, and then what are you going to do with that piece of paper afterwards, and so on. You might want to consider whether or not you've got the option of perhaps asking somebody to complete that electronically now, so that the data's straight away put in to an information system that you have, more likely to be put in correctly as well, and there's less opportunity for it to go walkabout. Employee relations, just general probably good housekeeping. So keeping your files in a locked cabinet. So quite many of you might think, yes, well, we have that already, but do you keep your keys hanging in that cabinet, or do you keep the key on your desk right next to that cabinet? You know, start thinking about things like that, and try and get a bit more savvy with what you're doing. Really do get friendly with your IT, or start researching software packages that you can have for spyware. Start using authentication programs so that you can double and triple check that people who are accessing your folders and systems really are who they say they are, and it's not somebody else who might have stolen one of your employees' login details. And just some tips here about how you can raise awareness amongst your staff, because you're only really as strong as, you know, the person with the least awareness about data security. And so here are some useful links where you can get some free material to try and encourage your staff to get savvy. Payroll is going to be a key area where people who are motivated by money, unfortunately, are going to be trying to target your business. So think about this as one of the more sensitive areas, and how you can improve security in there. Breach notification. Now, if you do have a breach, you are going to need to document it. If you have a serious breach, then you are going to need to notify the supervisory authority within 72 hours of awareness of that breach. Now, as I said before, our supervisory authority in the UK is the ICO, but if you have a head office that's based in a different EU member state, then you will need to report breaches to their supervisory authority. And you do need to include these 8 things within any breach that you report, okay? So you will need to be documenting the nature of the breach, the number of data subjects concerned, the categories of data, the categories of the data subjects that have been affected, the approximate number of records that are concerned, the name and contact details of the data protection officer or a suitable contact, the likely consequences of that breach, and most importantly, any measures that you have since taken to address that breach further and limit any damage that may result as of that breach. So that does bring us close now to 1:30, which is when we were due to end. So if you do have any questions, we can look at those for you and respond afterwards by email. Do send them through. And if you've got any feedback on the presentation today, it would be much appreciated, so I can think about what sort of things you might like to understand a little bit more and areas you're focusing on, and tailor it to what you want. And do give us a call if you have got some time left with us to discuss your issues. Let us know what you have, and we can speak to you on our advice line as well. So thank you very much. Thank you for bearing with us, and I hope you enjoy the rest of your day. Okay, thank you.